On 3rd of August 2011, the appellant known as Syahmie bin Hassan broke into and ransacked Rohani's apartment located in Ulu Kinta. He also brought rope which he intended to use against her. Rohani then came home at 6 p.m. and, discovering the existence of the appellant in her apartment, she screamed and attempted to escape. The appellant jumped on her and strangled her with rope. Struggling to escape, she fell, hit her head against the coffee table and became unconscious. While she was in that state, the appellant continued to strangle her with bare hands and curtains and only stopped until he was convinced that she was dead. He left the house but then came back later to have sexual intercourse with the dead body. He told SP5 about what he had done. He then gave SP5 Rohani's gold bracelet and asked him to help him to dispose of the dead body. They rolled up the dead body in a mattress and carried it to the car. While walking towards the car, a security guard approached the appellant and asked about what he was doing. The appellant replied that he was only taking an unknown woman to the hospital, but when he was asked further about why her hands and feet were tied, the appellant felt anxious and ran. The security guard called the police when he saw the dead body rolled up in that mattress. The appellant then met SP6 and asked SP6 to buy him a ticket to his hometown in Tanjung Malim. SP6 did as he was told and sent the appellant to the nearest bus station. While on his way to Tanjung Malim, SP5 told SP6 what had happened, which caused SP6 to lodge a police report.
911, what is your emergency?
Later that day, the appellant was arrested in Tanjung Malim.
So now, let's move forward to procedural history. This case was an appeal case from criminal trial in High Court Ipoh, as the appellant was charged under Section 302 of Penal Code. At the end of this trial, they found that the appellant was guilty and he need to face the death penalty. For your information, this case had been brought to the High Court for 2 times, as the first judge decided to transfer by having heard the evidence from 9 witnesses for the prosecution, while the second judge continued with the evidence with other 11 witnesses until the conclusion of the trial. Defendant then appealed and filed the case to the Court of Appeal in Putrajaya. The main concern regarding this appeal was to invoke and adverse the inference against the prosecution for their failure to call Dr. Swaran.
So moving on to legal issues of the case. The first one, whether the accused's actions from the time of breaking in and murdering showed an unsound mind, whether the medical diagnosis is sufficient and had been supported by factual evidence to satisfy Section 84 of the Penal Code for defense of insanity, whether the murder was pre-planned or an act of insanity defense, and lastly, whether the appellant suffering bipolar disorder, history of slow learning, odd behaviors and depression adequate to disprove the factual evidence of the murder.
So now, I would like to share with you guys what is the holding for this case. The court dismissed the appeal and affirmed the conviction because for someone who has bipolar disorder, he couldn't manage to check someone's heartbeat to ensure whether the victim itself was totally died or not. Hence, without any proper preparation, the appellant will totally fail to observe and wait until the right time to kill someone. As he was not laboring under any form of unsoundness mind, he should realize that all of his actions are totally against the law.
Next, we will see the referred case. The case referred to in this case is John Yongbe against Public Prosecutor, 2007. The relevant law to this case is Section 84 of Penal Code Act, Person of Unsound Mind. Moving on to the ratio decided that. The first legal issue is whether the accused's actions from the time of breaking in and the murdering showed an unsound mind. The ratio is by his attempt at disposing of the dead body and then running away after being caught red-handed carrying the dead body in a rolled-up mattress by the security guards. He obviously knew what he did was contrary to law. Though he had a medically recognized mental illness, known as bipolar disorder, we find that his conduct at all material times clearly defied the conduct of an insane person. Next, whether the medical diagnosis is sufficient and had been supported by factual evidence to satisfy Section 84 of the Penal Code for defense of insanity. Medical diagnosis alone would not be sufficient to sustain the defense of insanity under Section 84 of the Penal Code. It must be well supported by factual findings that fulfill the requirements under the section. Although SD1 had diagnosed the appellant to be suffering from bipolar disorder, he had never proposed that at the time of committing the offense, the appellant was incapable of knowing the nature of his acts. His evidence was therefore inconclusive. Next legal issue is whether the murder was pre-planned or an act of insanity defense. The ratio for this issue is the evidence that at the time of committing the offense, the appellant was not laboring under any form of unsoundness of mind, and he knew that the nature of what he did was against the law. It was in fact a premeditated murder. Last but not least, whether the appellant suffering bipolar disorder, history of slow learning, odd behaviors, and depression adequate to disprove the factual evidence of the murder. The ratio for this legal issue is the fact that he was diagnosed to be suffering from a certain mental illness coupled with histories of slow learning ability, strange behaviors, and depressive modes would not afford sufficient reasons to invalidate his apparently normal mental capacity at the time of committing the crime.
Moving on to the court's decision. After determining and taking into account all evidence presented, the court decides to dismiss the appeal and declare the precise conviction and sentence made by the trial judge against the appellant on the ground that, firstly, the court did not find the justification to interfere with the trial judge's decision in not questioning the prosecution's move of not calling Dr. Swaran to testify, as claimed by the defense, on the first ground that failure of the learned trial judge to invoke an adverse inference against the prosecution for failure to call Dr. Swaran. This decision was made under the explanation of it was the prosecutor's own right to establish and hold such discretion on the basis of their responsibility to prove the appellant's insanity is not burdened to the prosecution block, aligned with the fact that proving the appellant's insanity is solely up to the defense. In addition, it was crystal clear in regard to the matter that the prosecution possessed an absolute discretion in determining who they wanted or preferred to testify as a witness to prove its case, and in selecting which evidence to present before the judge. Another reason behind the decision is that there was no misjudgment made by the trial judge in rejecting the unproven insanity as raised by the defense in the second ground of failure of the learned trial judge to find that the defense of insanity had been proven on a balance of probabilities. In view of the fact that the approachment of the trial judge was nothing but correct through his consideration on every matter in defining and recognizing the said insanity of the appellant. Thus, the said judge was convinced that the appellant was not legally insane during the time he committed the offence. Furthermore, the reason behind the distrust put by the learned judge on the defense's excuse of the appellant's insanity is, after examining all evidence, due to the consistency of the crime's execution, which was made by an intelligent person with a sound mind since the moment the appellant broke the house until his attempt to conceal his crime.